Hi, this is Jennifer Wilson, and this is my discussion point on the 5 key differences in chapters 7, 11, and 13 bankruptcies. Number 1, a chapter 11 bankruptcy is the most expensive and time-consuming of the bankruptcy elections. However, its number of filings make up less than 1% of all bankruptcies filed. A chapter 7 is the shortest of all bankruptcy, shortest time frames of all bankruptcy elections, generally from filing to discharge is 60 to 90 days. A chapter 13 can last up to 5 years, and a chapter 11 can remain open for a number of years. Number 2, a business cannot file a chapter 13. However, a business can elect between a Chapter 7 and a Chapter 11 based on its asset values and liability balances. A Chapter 11 allows a debtor in possession to remain in control of the business, continuing to operate while being monitored by the U.S. trustee, where a Chapter 7 is a liquidation proceeding. Often a Chapter 11 may convert to a Chapter 7 once it gets going and sees it can't make it happen. Number 3, the Chapter 11 classifies separate creditors into impaired and unimpaired, and based on whether they're secured or unsecured and whether you can do anything to their values or their payments or their terms, such as a mortgage, for instance. Is an unimpaired creditor. You can't touch its value. If you want to keep your house, you got to pay for it according to its original terms. Similar to Chapter 13 for a secured creditor, but these creditors have differing rights based upon their classifications. Chapter 7 and 13 don't have all these different classifications, even though Chapter 13 may have some priority creditors based on whether their taxes are court-ordered proceedings. Number 4, Chapter 11 bankruptcy essentially forms a partnership between the debtor in possession and its creditors. Certain creditors, based on their positions or their classifications, have the right to vote on the plan proposed by the debtor in possession, where creditors don't have a vote on the plan in Chapter 7 or 13. Any objections they have will be raised through motions before the bankruptcy court. And number 5, a Chapter 7 offers no cram down option. It's just what you see is what you get. You either keep it or you give it back. The Chapter 13 does allow for some cram down on valuations, but the cram down is not dependent on actions of other creditors, where in a Chapter 11, a cram down is available if at least one impaired class has accepted the plan. That's my presentation. Thank you.